Precedent is the third most important source of law. Precedent exactly means the rules or principles decided in a case which has substantial value, and this substantial value would be followed by the inferior courts in their subsequent practices in the similar nature of cases. So regarding precedent, we found a difference of practice in England and in continental countries such as Germany, France, Italy, etc. So in England, it was the decided cases which are enjoying far greater importance, and those principles and rules which were decided by the superior courts would likely to be followed by the inferior courts, and this is a common feature in English law or common law. But in continental countries, the judges only look at the statute books in deciding all cases. So, the role of precedent in continental countries like Italy, Germany, France, Spain, etc. has no importance. In defining precedent, Salmond defined it as a product of decided cases, and it is an integral part of English law or common law or the unwritten laws of England, while Justice Gray defined precedent as a rule for subsequent practice and a set pattern for future conduct. Professor Keeton defines precedent as judicial decisions which enjoy high authority in the judicial system to be followed by every inferior court in the judicial system. Professor Jenks defined it as a decision by a competent court of justice to be followed by inferior courts. There are certain reasons for the very acceptance of precedents, and those reasons are: one is it bears practical experience. So Professor Allen says that judges as the interpreter of social mind. The second reason of acceptance of precedent is the convenience of it due to settled laws which save the labor and time of judges. The number 3 reason for acceptance of precedent is precedents settle those rules and regulations which prevents error of judgment by individual judges. Then the fourth one, it prevents partiality in the part of judges due to, as already settled rules and principles are there in the previous decisions. Lastly, precedents helps the lawyers to take cases how the development of law due to the past judicial experiences. So these are the 5 reasons why precedent was widely accepted in almost every judicial system in a modern democracy, as it was developed and originated from English judicial system. Gradually it expanded into other legal systems like India, United States of America, and some other democratic countries in Asian continent or American continent, even in the African continent.